Hi, everyone, and thanks for joining us here at PIA's The Break, our video series currently about legislative priorities. So today we're going to talk about one of our New Jersey legislative priorities, which is producer comparative negligence. It's a great topic to watch a quick video on rather than try to read about it. And so here to explain it is one of our attorneys, and as well as our Director of Government and Industry Affairs, Brad Lachut.
Thank you very much, Claire. I'm not sure if I should take offense to that, considering I'm the one who writes a lot of the stuff on producer comparative negligence, but I'll take it as a compliment. So thank you, everybody, for joining us. As Claire mentioned, we're talking about one of our legislative priorities, and that is producer comparative negligence. So what's the problem? What is this that we're talking about? So insurance producers in New Jersey are held to an inconsistent standard of care. Standard of care is basically the obligation that you owe to another to act reasonably. If we're going to look at that in the non-insurance world, it's the obligation that you have to others when you're driving your car to drive reasonably. If you were to swerve all over the place and speed, that would be negligent behavior. And if you caused any injuries, you could be held liable for it because you've breached your standard of care. There's a similar standard that applies to insurance producers in their dealings with their clients. The problem is it's not the standard of care that is applied to maybe everyday life that we are used to. Let's talk about that a little bit more. So when we're talking about the standard of care for insurance producers dealing with their clients, brings into a conversation a topic called special relationship. Now, courts in New Jersey have found that if there's a special relationship between a producer and a client, that the producer's standard of care is higher. It's called a fiduciary standard, and under that standard, a producer would be unable to assert certain defenses, comparative negligence, which I'll talk about in a minute. Now, the problem here is that courts have applied a special relationship inconsistently. It tends to be fact specific and has to do with a number of factors, including, length of time the producer's known the clients, the level of involvement, the sort of compensation structure, things like that. Unfortunately, the courts have not created any sort of rubric, and it is inconsistently applied. One of the seminal cases on producer standard of care is a case where the court found a special relationship and the producer knew the client for all of 5 minutes, a matter of hours and not days. So that was clearly maybe an inconsistent application. That inconsistent application leads to the issue that producers are having of there's an increase in case settlements and then a commensurate increase in E&O costs because carriers can't be sure of what the outcome of the case is, even if an insurance producer has done everything right. I'll get to that a little bit when we talk about comparative negligence. They don't know what the outcome is. So the case is going to settle over and over and over again, and there's maybe an incentive to bring these cases because there's going to be an incentive to continue to settle them. Let's talk about the comparative negligence and why that matters, what that is. So comparative negligence is the legal principle that damages are shared between the plaintiff and the defendant when fault lies with both parties. So when I was talking about the driver before, if the person's driving erratically, that person has breached their duty. But if they hit a car that actually ran through a stop sign, that other car had also breached their duty, and the damages would be offset by the negligence of each. Now, applying that to an insurance example, if you had a policyholder or a client comes to a producer and wants to buy a homeowner's policy, they tell the producer that they want a homeowner's policy. Oh, by the way, they have a pool in the backyard. Could they get the coverage? Great. The policy is provided, has all the coverage on there. Client doesn't read it, but the client forgot to tell the insurance producer they actually have a basement, or they have a basketball court in the basement as well. The basketball court catches fire, house burns down. The carrier says there's no coverage because we didn't know there was a basketball court in the basement. The client then sues the producer saying, you should have had this coverage for me. The producer says, I didn't know. Well, if a special relationship is found, the producer couldn't say, hey, you didn't tell me about that, because that would be a form of comparative negligence, and that defense is not allowed when a special relationship fiduciary standard is applied. That's kind of a crazy example, I know, but it's also a real example that has actually happened. So that's an example of why this is an issue and why we're looking for a solution. And that is PIA of New Jersey has proposed legislation that would permit insurance producers to use all common law and statutory defenses, including comparative negligence in lawsuits. This defense is currently available in virtually every party in New Jersey courts and in other states to insurance producers in almost every case as well. So this is not a revolutionary standard at all. It is actually the majority standard and the vast majority of court cases. This also does not forgive producers or give them license to act poorly. Producers would still be liable and should be liable for their own actions. This would just allow for a more fact-specific analysis and allow producers to provide a defense in a case. So that is what we have, and that's what we'll be pursuing. So what can you do? The biggest thing you can do is watch your inbox. If you see PIA, don't delete it. Take a look and see what it is, especially if it's an advocacy call to action, because we will be asking for your help on this. This is a big issue. We know it's an important issue to producers in New Jersey. So we are going to need your voice to help get this through. If you have any E&O horror stories, send them our way. I like to read them. It's fun. But they're also going to be useful when we're in meetings. We can talk about what the issues are. These real life examples are so helpful to illustrate the points for legislators who often don't necessarily understand this. If you need updates, check our publications, not only the dispatch and news and media, but also social media as well. And if you're interested in talking about this issue with legislators, contact PIA, let us know. We can arrange some district office visits. Maybe Claire and I could join you. And then if you have any questions on this or anything else, you can turn it over to Claire and I. And with that, I will actually turn it over to Claire for any questions she might have.
Yeah, now I understand why on my insurance application, I was asked why I had a basketball court in my basement. But just to make sure I'm clear on what comparative negligence, it's the producer can effectively argue that they weren't told they have no duty to know about the basketball court in the basement. But if they had left the pool off, or let's say forgotten to include the family dog on the insurance policy and the coverage wasn't there, they could still be held liable for those errors, correct?
Absolutely, yeah. The basketball was like kind of an extreme, absurd example to illustrate the point, but definitely more mundane things absolutely would be included in there as well. 100%. So there's a lot of E&O dangers in New Jersey.
Yeah, so less not trying to. Still, insurance producers have to have a duty to their clients, but just make it more predictable so that E&O costs us. Maybe not leave the nation in E&O premiums.
Yeah, and to your point on this question too, if a policyholder failed to tell the producer about a pool, and there wasn't coverage and the producer didn't ask about it, it could be held reasonable that the producer should have asked about it. So that producer could be held liable even under this legislation. It would just be for the judge and the jury to look at all the facts and decide that, which is really what we're striving for, is basic fairness in that civil process.
Yep. It's somewhat complicated legal issue that once broken down, it's makes, at least for as a very biased source, makes sense. I will note that this is our second video in the PIA New Jersey legislative priority series. So in the other one, we talk about the actual legislative session in that process. So I highly recommend watching the step down video, both for another priority and for some insight into that process. Unless Brad has anything to add, thanks for watching.
Good. Thank you, everybody. Appreciate it.